talk about preliminary agreements. I want to start by really just making sure that we're on the same page with what a preliminary agreement is. In many commercial negotiations, we don't go straight from offer to acceptance and the creation of an agreement. What will happen is that there will be some kind of term sheet, some sort of broad outline of what the parties might agree, and then a whole heap of negotiation around the detail. So often, in order to just make sure that the people around the table are of the same mind as to what the detailed agreement should look like, the parties will get together and agree a term sheet of some sort. Sometimes it's called a term sheet, sometimes it's called heads of agreement. Other kind of preliminary agreements might be a confidentiality agreement or an exclusivity agreement. So some sort of arrangement between the parties that sets out that they're going to exclusively negotiate with each other with a view to ending up with an arrangement in place. But it might or it might not be intended to be binding. So in this little section, in this little video, I'm going to outline what the key legal issues around preliminary agreements are, so we can discuss them in the classroom or on the discussion board. So what is a preliminary agreement? It's really anything that arises out of what the parties negotiate as being the principal terms of a proposed transaction. So it's a document that they might enter into with the intention of recording their agreement on the basis that there will be a more formal and binding arrangement in the future, that this preliminary agreement will be replaced. So a preliminary agreement might, for example, state that the first party agrees to buy item X from the second party for Z dollars. And it quite often will state this agreement is subject to contract or subject to the preparation of a final contract. I often see them in practice as saying the only provisions in this agreement that are intended to be binding are, for example, the confidentiality clause. So the issue that arises here is what happens if one party wants to withdraw after a preliminary agreement has been entered into, but before the final agreement is signed. The question ultimately becomes, is there a contract? Or because if there is no contract, there's nothing to stop that party from walking away. If there is a contract, if there is a binding arrangement, then we need to work out exactly what is binding. And what that says about the party's ability to walk away or to talk about the deal with somebody else. And ultimately, this is a question that comes back to whether the parties intended to be legally bound by the preliminary agreement. The key case here is Masters and Cameron, and it provides the insight that there are three types of preliminary agreements. There are those where the parties have finalised the terms and they intend to be bound immediately. And those kind of agreements are binding, whether or not more formal document is ever signed. Secondly, there's the type where there is an agreement on the terms between the parties, but the performance is conditional on executing a further document. And in that case, the parties are bound to execute that final contract. So no agreement yet, other than the agreement to execute that final document. The third type is this idea that there's no intention to be bound unless and until the parties execute a formal contract. And that kind of agreement is not binding. So in Masters and Cameron, the parties had signed a written memorandum relating to the sale of some farming property. The memorandum was signed by both parties and it recorded the vendor's agreement to sell and the purchaser's agreement to buy the property for a stipulated price. The portion of the document signed by the vendor said, this agreement is made subject to the preparation, it's subject to the preparation of a formal contract of sale which shall be acceptable to my solicitors on the above terms and conditions and to the giving of possession on or about 15th day of March 1952. Both parties behaved as though the transaction was proceeding, so there was evidence before the court that the parties were acting as if they intended to be bound by the contract. But ultimately, no further document was ever signed. When the purchaser ran into some financial difficulties, the purchaser said, sorry, no contract. We said that we were going to sign a contract further down the track. We didn't do that, so there is no agreement. And the vendor said, hang on a minute. We intended to be bound. There is enough certainty, and we'll talk about certainty next week, in this arrangement. So what happened? The High Court observed that this case could fall into one of those three categories that we talked about just a moment ago, ultimately saying that cases of the third class aren't intended to have and do not have any binding effect. So what kind of class did this agreement fall into? The High Court held that the effect of the preliminary agreement depended on the intention disclosed by the language used by the party. The use of the expressions such as subject to contract and subject to formal agreement indicates that the preliminary agreement wasn't intended to be binding. On the facts before the court in this circumstance, there was nothing to displace that presumption. The stipulation that the formal contract was to be acceptable to the vendor's solicitors indicated that it should include any additional terms that the solicitors considered appropriate. The memorandum did not, therefore, record a binding agreement. The purchaser was free to withdraw from the transaction and was accordingly entitled to a return of the deposit. So these key words, subject to the preparation of a formal contract, acceptable to the solicitors, was enough to provide evidence that the contract fell into that third category. Subsequently, the case of Baulkham Hills Private Hospital and GR Securities, which is in your textbook and I think is also in your casebook, indicate the idea that there might in fact be a fourth category. That's a category where parties intend to be bound immediately and exclusively by the terms they've agreed on, while expecting to make a further contract in substitution for the first, containing, by consent, some additional terms. In Anaconda, Nickel and Tarmula, Australia, also referred to in your textbook, a letter signed by both parties to set out the proposed terms of an agreement relating to a mineral exploration venture was considered. That document concluded with the words, "The above forms a heads of agreement which constitutes an agreement in itself, intended to be replaced by a fuller agreement, not different in substance or form." The full court of the Supreme Court of Western Australia, by a majority, held that the heads of agreement in that case was intended to be binding and fell within this fourth category explored in the Baulkham Hills case. There has, as your textbook points out, been some debate as to whether this fourth category is even necessary. The weight of authority supporting the idea of this extra category ensures that it will continue at the very least to inform our analysis and our thinking about whether a preliminary agreement is in fact binding or not. Professor McLaughlin, referred to again in your casebook, reminds us, though, that it's important not to lose sight of the fact that there are really only two categories of preliminary agreements, those that are intended to be immediately binding and those that are not. Each of the three or four other categories are just a way of falling into working out what the answer to that question is. Is it binding now or is it not? So before we finish up on this topic, I want to bring your attention to some of the recent cases, because we have quite a lot of old cases here. And it does seem sometimes that intention in particular is something that really might not, particularly since Irma Genus, be at the forefront of the minds of lawyers who are both writing contracts and those who are trying to pull them asunder. So in 2015, this New South Wales Supreme Court case of Pavlovic and Universal Music Australia really provides a very good outline, particularly of the preliminary agreement matters. So Chief Justice Bathurst's decision in that case is well worth looking at, and I'm quoting from it on the slide extensively. He says there that it's well established that the question of whether the parties intended to bind themselves to a contract is to be determined objectively, having regard to the intention disclosed by the language the parties have employed. That comes straight from Masters and Cameras. In cases such as the one that the court was making a decision about at the time, which don't depend on the construction of one document, so there are multiple documents involved, what is involved in the objective determination of the question from the communication between the parties and the context of the parties dealing over the time leading up to the making of the alleged contract is what's important. And this involves considering the subject matter of the communications. He refers back ultimately to Air Great Lakes, one of the cases that we discussed at the very beginning of this series of the mini videos, which includes a consideration objectively of what the parties said or wrote. Even more recently, this case of Lakis and Lardis, which has only been decided in March this year, the judgment of Justice Sakar, it's quite a small section of the judgment, but is worth having a look at because it specifically goes to this question of intention and provides a really good summary, I think, of what the cases we've discussed up to this point said. So directly from the judgment, he says, for an agreement, either oral or in writing, to be binding, the parties must manifest an intention to create legal relations. This requires making an objective assessment of the state of affairs between the parties, as distinct from the identification of any subjective reservation or intention. So the objective test remains at the forefront. Three other quotes that I think are really important from that judgment are on this slide. Essentially, again, citing Ashton and Pratt in another case, Vroon and Foster's Brewing Group, he says, formal language of offer and acceptance isn't required for a contract to be formed. And we've seen this over and over again. We just use that objective test. Did somebody intend, would a reasonable person having the knowledge of everybody involved believe that the person making the conduct that making the statement or the conduct that is being put forward as being an offer, would they see that as being in fact an offer capable of acceptance on its terms? Secondly, the commercial context and the parties' previous dealings are relevant to determine whether a binding agreement has come into an existence between the parties. He cited there Pavlovic and Universal Music, the case that I just mentioned. And lastly, oral contracts for the transfer of property will also need to be supported by valuable consideration, be certain in terms, and comply with the statutes of fraud requirement. In other words, in order for a contract, in that case for the transfer of property, to be binding, there needs to be offer and acceptance or agreement, otherwise manifest. There needs to be an intention to enter into a legal relationship. There needs to be certainty and there needs to be consideration. And because it's property, it needs to also comply with the statute of fraud requirement, which is the formalities requirement that we'll discuss in a couple of weeks' time. Lastly, I just want to remind you about the overview, the place that we started. So all of the discussion up to now leads us to this, to be able to provide a framework for determining whether intention to create legal relations exists. So the general rule is that there must be a voluntary assumption of a legally enforceable duty. The authority for this is Australian Wool and Mills. Without that voluntary assumption of a legally enforceable duty, which we determine objectively, we cannot have a contract, even if all of the other elements exist. Where there's no express statement, then we look at the kind of conduct and we check it objectively. We think about the relationships, is it a domestic or social relationship or a commercial one? But really, since the homogeneous decision, that really goes to who has the onus of demonstrating that a contract exists rather than really a rebuttable presumption in the strongest sense. We also need to think about what the nature of the agreement is. If it's a preliminary agreement and the parties intend to replace it with something else in the future, we need to think about the categories in Masters and Cameron at the very least, and perhaps pull out of Borkham Hills the identification of that fourth category. But remember, ultimately, no matter how many subclasses we look at, there are two types of preliminary agreements: those that the parties intend to be binding and those that they don't. Where do the difficulties arise? Well, we've talked about that, particularly in honour clauses and letters of comfort, and they tend to be the most tricky things in commercial dealings for us to deal with around intention. Agreements with government, and we'll see that arise in the cases from time to time, being able to differentiate between where the government is entering into a contract and where they're just making some sort of policy undertaking. So that's all I have really to say to you about certainty. Going forward, about intention. Going forward, the next topic we'll be covering is certainty, and you'll need to prepare by reading Chapter 6 and going through the Learning Guide Topic 6. And of course, check your understanding of this material and that material using the online quizzes through Mentor, the Thomson Reuters Mentor product. Questions, concerns, frustrations, compliments, any of the following or any of the above, please feel free to email me or get onto the discussion board, share your thoughts with other students, see how you can help each other learn. Thanks for listening.